Great news for people living in California. A federal judge just struck down the state's ban on high-capacity magazines. The law stated that no person shall possess or import or traffic in any magazine over 10 rounds, which is pretty small by modern standards. In fact, the term high-capacity magazine is a bit of an anachronism these days, considering that the average gun, their standard capacity is well over 10 rounds. In fact, there are few guns throughout history in which 10 rounds was their standard capacity. I can think of maybe the SKS and the Lee Enfield, but that's about it. Standard magazine sizes vary from 5 in some guns to 7 in a 1911 to 20 in an old M16, and then 30 in most AR-15s and AKs. And of course, the Glock 19, one of the most popular handguns in America, has a standard capacity of 15 rounds. You might be wondering, why am I reeling off all these numbers of magazine capacities to you? It doesn't really matter. Well, actually, according to the judge, this was a part of his justification that he used to strike down the law. Essentially, he said that this puts an undue burden on gun owners in California because the law essentially prohibits what are otherwise very common types of magazines, which is similar to the argument in the Heller decision, basically saying that you can't ban anything that's sort of commonly available and widely adopted throughout, sort of the community of gun owners. Essentially saying that by restricting someone to 10 rounds, you're putting an undue burden on them because then they have to go out and actively seek 10-round magazines over the more commonly available, 17, 15, and 30-round magazines that you would find in most gun shops in, say, Texas or Florida or Alabama. Now, the judge sort of founded all of his argument within the idea that the Second Amendment protects self-defense, which, the phrase self-defense does not appear anywhere in the Second Amendment in the text. That's sort of been read into it over the centuries. I mean, really, if you go back to when the Second Amendment was adopted, it's pretty clear that the point of the Second Amendment was to ensure that the government was not better armed than the populace. Because if you had all the arms in the hands of the state, in the hands of, the police and the militias, well, then there would be a higher risk of tyranny. Ideally, if you have a well-armed populace, the people would not need to actually resort to self-defense against the state. The idea, then, is that if the people are well-armed, the state will not act in rather tyrannical ways that would prompt people to try and fight back. Now, unfortunately, even though this has been struck down by one judge, this will now work its way up the court system, because I'm sure California is not going to give up on this very easily. So the next step, apparently, in the chain is the Ninth Circuit Court of California. Actually, I don't know if the Ninth Circuit is just in California, but it's largely based in California. I know that. And, of course, that's considered to be, one of the most left-leaning courts in America. So this will likely be ruled the other way and in California's favor in the next stage in the court system. However, I'm sure the NRA, considering the NRA is backing this lawsuit monetarily, they will not let it in there, and they'll keep working its way up until we get to the Supreme Court. And thankfully, even though I don't think Brett Kavanaugh is a particularly great justice, his one thing that he is really good on is the Second Amendment. So as long as John Roberts, which that's a big if because John Roberts really is turned into kind of to the left of Anthony Kennedy. Certainly, though, Kavanaugh, Gorsuch, Alito, and Thomas will all side against California if this were to go to the Supreme Court, which I don't see how it doesn't at this point. It'd be very nice to see that go the right way. I'm cautiously optimistic at this point. Now, while I'm very happy from an ideological standpoint to see this law getting overturned, from a legal standpoint, I actually disagree with the decision. I don't think that California's law is at all unconstitutional, and it's not because I think that the Second Amendment somehow allows magazine bans. I don't think that at all. I think that under the Second Amendment, if interpreted properly, you cannot pass any gun control laws. However, the Second Amendment does not apply to the state of California. The Second Amendment is in the Federal Bill of Rights. So we have different bills of rights throughout the country. Every state, well, for the most part, has a Bill of Rights, and then there's also a Bill of Rights at the federal level. These things do not overlap. The state Bill of Rights do not apply to the federal government, and the federal Bill of Rights do not apply to the state. Or at least they didn't until the invention of something called incorporation doctrine in the early 20th century, in which the Supreme Court decided to incorporate the Federal Bill of Rights into every state. But before that, we know that in the time of the founders and all throughout the 19th century, the Federal Bill of Rights did not at all apply to states. Because if the Federal Bill of Rights applied to states, then states would not need to have their own Bill of Rights that looked very similar. You know, most states have some amendment to their Constitution that reads very similar to what the Second Amendment reads. California, however, is not one of those states. There is no so-called Second Amendment mirror in the California state constitution. That means that, I mean, frankly, California could ban all guns tomorrow and rule that, or pass a law saying that, you know, hey, if you're caught with a gun, we're going to execute you on spot. That'd be perfectly legal. It's just that the courts now are so far away from what the law originally was. They're so based on they're so rooted in precedent rather than the actual Constitution that nobody really cares anymore. And of course, you might be saying, well, yeah, that may be true, but at least if the Bill of Rights is incorporated to the state constitutions, then the right to bear arms is protected in all 50 states. Well, not really, because just in the same way that the judges sort of neglect the law by inventing the incorporation doctrine, they also stray from what the Constitution says when interpreting the amendments. So the Second Amendment is interpreted to mean something much weaker than it was originally intended. All gun laws at the federal level are unconstitutional. Yet the Supreme Court does not agree. That's because the Supreme Court has many different examples of precedent that's been set in the past by judges who have moved the line as far as exactly what the Second Amendment protects. And so the result is that you overall, even though the Second Amendment applies in all 50 states, you get a Second Amendment that is much weaker than how it was actually written and intended to mean. So to sum up this, I disagree on legal grounds with the decision in California this week to overturn the law banning high-capacity magazines, though I'm very happy about it from an ideological standpoint. And obviously, it is everyone's right to own whatever they want. No state has the right to tell their citizens what they can and cannot own as long as they're not hurting other people. I think that's true universally across the planet. But the matter of what the Constitution says and means is a totally different one from what your rights are. You know, one is interpreting a piece of paper, the other one is a moral and philosophical question, which is a little too big for me to answer in under 10 minutes. So if you gained anything of value from this video, I'd appreciate you clicking that like button and subscribing, because I do upload every day, and I'll try and stay on top of this news and see what ends up happening when the Ninth Circuit Court makes their decision. So I'll see you all then.